5 seconds to go. Start. The factors as noticed herein above may not be decisive of the matter when taken singularly, but when the entire chain of circumstances established by way of undeniable facts and the proven facts are juxtaposed with these factors and all the relevant factors are joined together, the present one turns out to be a case where the burden envisaged by Section 106 of the Evidence Act operates heavily against the appellant. The victim was none other than the wife of the appellant and was living with him. Thus, the basic fact as to when did he part with the company of his wife was within the knowledge of the appellant alone. He explained nothing in that regard. Secondly, when the appellant's wife was found killed with a dead body carrying special injuries and the cause of death having been asphyxia due to throttling, the appellant was required to explain such injuries which the deceased sustained while living with him in the same dwelling house. Again, there had not been any explanation from the appellant. Thirdly, if his wife, who was residing with him, had been so ill as to be taken to hospital, the facts in that regard were also especially within the knowledge of the appellant, and he was required to explain the nature of ailment as also the mode and manner by which she was admitted to the hospital. As noticed, there is no explanation on these aspects from the appellant. Rather, the narrative cooked up by the witnesses and picked up by the appellant about the alleged ailment and hospitalization of the deceased is found to be of utter falsehood. Fourthly, if his wife had died and still he had gone to some other place, the reason for doing so was also especially within the knowledge of the appellant alone. The reason, as assigned by the appellant about his own illness, is also found to be far away from truth. Fact of the matter remains that all the aforesaid facts and factors which ought to be in the knowledge of the appellant are either not clarified or the explanation given by the appellant turns out to be false. Hence, in the given set of facts and circumstances, the legal consequence is that such omission coupled with such falsehood indeed provide additional links in the chain of circumstances. Thus, the sum and substance of the matter is that the falsehood cooked up by the witnesses regarding illness and hospitalization of the victim and readily accepted by the appellant, coupled with the undischarged burden of Section 106 of the Evidence Act, provide such strong links in this matter that the chain of circumstances is complete, leading to the conclusion on the guilt of the appellant beyond any doubt. The other submissions, as regards the doubts on site plan Exhibit 3 or on the date of arrest of the appellant or about the place from where the dead body was carried to the police station, have only been noted to be rejected. The IOPW7 has categorically established that he had drawn the plan Exhibit 3 at the site and the same could not have been removed. Stop.